Okay, let's get started. It's 12 o'clock. Thank you all for registering and attending today's webinar. I have all lines muted and I'm recording the webinar. I'll send you both the slides and the recording in a couple of days so we have time to process the recording on our end. I'm Jeff Anderson. I'm an attorney in the banking practice group at Dickinson Law Firm. My practice is primarily focused on regulatory compliance for community banks and other community institutions. So today's webinar, I'm going to focus on three topics. First, a very brief TILA RESPA integrated disclosure update. Second, a walkthrough of the privacy notice rule that came out at the end of last year, and step-by-step how to comply with the rule. As I started preparing for today and working through that privacy rule a little bit, you read summaries of it and it seems so simple, but then you dive into it in a bit more detail and all of a sudden it is unnecessarily complex. And then lastly, I'm going to go through and talk about some recent enforcement actions that have come up in the past 2 to 3 months and case law in the banking area. There's been a lot of activity there, so just want to give a summary of some of those cases. So first update on the TILA RESPA integrated disclosures is the recent amendments that were made on January 20th. These are relatively simple amendments, but I want to make sure to highlight them so you can get them in your policies and procedures as soon as possible. The first change involves providing a revised loan estimate on the interest rate lock. So under the previous final rule, isn't it fun with the CFPB where you get multiple versions of final rules and you can talk about the 2014 final rule versus the 2015 final rule. Everything seems to be somewhat interim, but the previous final rule, you had to provide a revised loan estimate on the date that the interest rate was locked. As you can imagine, that'd be really cumbersome for lenders and really difficult, I think, for borrowers as well, because now as a lender, you're going to have to lock the rate in the morning. There's no way you're going to be able to do it any other time. It just created a real administrative and operational problem. So the CFPB went back and under the January 20th final rule, which will take effect August 1st along with the rest of the integrated disclosure rule, now you have 3 business days after the rate is locked to provide the revised loan estimate. Simple enough. The second change is the previous rule. This is just a mess up by the CFPB that they had to fix. So under the previous final rule, there was language that permitted you to reserve the right to issue a revised loan estimate anytime prior to 60 days before consummation, but to do that you had to include a statement in the loan estimate reserving that right. But the way they had that initial rule laid out, they messed up and they said that you have to reserve that right, but then later in the rule said you can't make any modifications to this form and didn't list that reservation of rights as one of the permitted modifications. So you're required to do it, but you can't do it. So they've amended that in the new final rule. Now you can provide that on the loan estimate and it's not an issue. That's really it for the January 20th rule. I wanted to spend a little bit more time on the TILA RESPA integrated disclosures. As you're all aware, there's no way in a 20-minute presentation I'd be able to even scratch the surface of the integrated disclosures. These rules are going to be something that lenders are going to have to get trained on. I mean, the CFPB and their estimates that they put out for the time and costs that will be required to comply with the new rule, which are usually always comically low, right? They always estimate the costs and time much lower than it actually turns out for particularly smaller institutions. They estimated that loan officers would need a full day of training on these new rules, and I think that's right. So I really just wanted to go through some of the more higher level operational questions that have been raised to me lately here in Iowa and issues that I've seen percolating around. I'm focusing more on a high level. Once we, as you all know, because you all have dove into this level of detail, but once you dive into the forms and start getting into questions and detail on the forms, it's a real hornet's nest, and it would completely eat up our time today. Again, we wouldn't even be able to scratch the surface. So quickly go through a few of the questions that have come up. So a few that I've seen that people ask me have revolved around the application. So one is, what if you, the lender, you get the 6 elements that are for an application? So I'm not going to go through every piece of the rule, but you all know under the new rule, you get these 6 elements that qualify as an application, and that triggers the disclosure requirement. There's no 7th catch-all anymore that you can rely on. And honestly, not many institutions that I work or talk with really utilize that 7th. But so when you get those 6 magic elements and you have an application, what if you get them and you don't have the loan type or term? How are you supposed to provide any type of estimate? I mean, those are 2 of the key things you need to provide a meaningful good faith estimate. How would you do that? So what you can do is you can limit this occurring by sequencing how you collect the information. And you can try to collect that loan type and term information earlier on in the sequence so that you have it by the time that you get the magic 6 elements. You could also, if that fails, you can ask for this information after you get the magic 6. It's just not going to delay the timing, your disclosure timing. So you're free to ask for it and try to get it and say, listen, we want to provide you with a real estimate, and we're going to need the loan type and the term that you're seeking to provide that. You can do that, but it's not going to delay or change your requirement to disclose. Otherwise, if you're still, you implement these safeguards, you have the 6 elements, and you still don't have the loan type or term from the borrower for whatever reason, maybe it's an online application, you still have to provide the estimate. So then it begs the question, well, what do we provide it based on? I'd recommend just having some across-the-board policy that we're going to provide, in this instance, if this happens, we're going to provide an estimate based on whatever your most common mortgage product is. A 30-year fixed-rate mortgage or whatever it may be. But just have it across the board. And you can, that's just my recommendation I have on there. You could set it at really anything as long as it's a real thing that you offer. But I would recommend really doing it across the board so that you're not, it removes another layer of subjectivity from the process. A follow-up question to this would be, well, okay, can we refuse to accept an application because it doesn't have the loan type or term? So up above, I said you can ask for the loan type or term as part of the sequence, and you can ask for it after the fact even, but you can't require them and withhold the ability for them to submit the magic 6 bits of information on the basis that they don't have, that they're not providing things like the loan type or the term. So once they've provided the 6, it triggers it regardless. You can't hold it back because they didn't provide the type or the term. But you can sequence it. So if you imagine the easy way to think of sequencing is like an online click-through. If you have a click-through and they enter the desired loan type and term and then click next and fill in the 6, you'd be okay there. So again, on the magic 6, what if the applicant enters the magic 6 on an online application and saves it? Have they submitted it? Does that trigger anything? A lot of online loan application software, you can click submit or you can click save and save it for later. Maybe you have to go home and get some more information to fill it in more fully. If they enter the 6 and click save, it's not an application. They have to submit it. They haven't submitted it if they just click save as opposed to submit. even if you can access it on your system and see it. They've saved it on their end, and they need to go back and actually submit it to you to trigger the disclosures. Still on the Magic 6, what if a current customer is applying for a loan and you already have the Magic 6 on file? So, you made a loan to me 3 months ago, and you collected all my information. Now I come in and I want a home loan. You already have my Magic 6, so do you have to disclose right away once I express an intent to get a loan? No, you don't. That's not an application. The applicant has to submit the Magic 6 specifically for the loan in question. It can't be, it's not going to trigger anything because you have knowledge of the information wholly outside of the mortgage loan in question. Now, you can still refer to previously submitted information, so that's not saying that you can't use, if I was in a week ago for an auto loan and you collected that information, I come back in for a home loan, you can still use that information and, pre-populate an application form partially or something, but you're not required to, and it's not going to trigger it on its own unless you really choose to move it over and use that information for the mortgage loan in question. On the forms, I'm not going to, again, dive into line-by-line detail in the forms, but at a high level, to what extent does the rule mandate specific formatting, font size, type, layout, font type, all of that? So there's always kind of a sliding scale with forms that regulators provide, where one might be, this is really just an example. You're not required to use it. You're free to use what you want. 10 being, this is a required form. You have to use this form. You have to use this formatting. And there's a lot in between, or maybe it's a model form where you get a presumption of compliance, like the privacy notice we'll talk about, but you can use your own format as well. This one is definitely more closer to the 10 on that range. It's not a model. It's a mandated form. You have to use this form. So as you're working with your vendors that are providing these forms, keep that in mind that these need to look as close as possible, have the shadings where the form has shadings, have things bolded where it's bolded, font size reasonably similar. The rule doesn't state a specific font type, but I would use a font type that looks as close to the model as you can. I wouldn't use Comic Sans or something like that on your loan estimate and closing disclosures. Another question, and this is another one I think the CFPB kind of messed up a little bit. The preamble, if you read through the preamble, I hope none of you had to, but if you do, it seems to say that owner's title insurance is subject to the 10% variance. But then that's not really reflected in the final rule when you read it. So it's left a lot of people wondering, well, which do we follow? Is it subject to the variance or isn't it? There's no special variance rule for owner's title insurance. It's dependent on the circumstances, whether it's optional, whether they're given the ability to shop for it. So if you're not requiring it and it's listed as optional, contrary to what the preamble says, there's no variance. There's no 10% variance. Even if it's paid to an affiliate, it can vary up or down as high as you want it to. When I say no variance, I don't mean that it's zero tolerance. I mean that the variance doesn't matter. It's not subject to a variance requirement. If it's required, then that's going to change it. Another one is loan purpose. So what do you disclose for construction to permanent loans? Do you disclose it as construction? Do you disclose it as permanent? There are a lot of questions like this when you go through the form and you really start sitting down and working through them about, well, what do we put in this box? This term or this term? Because what we have is a product that's kind of a mix of both. As you really start to work with your forms and train on them, a lot of these types of questions are going to come up. So I think if you're doing a construction or permanent loan and you're handling it as a one-time close with one set of disclosures, it's a purchase. That's the purpose. That's the ultimate end goal. If you're doing it in two phases, one set of disclosures for the construction, one set for the permanent, then you disclose them differently. One would be construction, one would be purchase. Another broader issue that dovetails on this, on the loan purpose, is what about these other types of loans where you don't have I call it the mandatory form, the mandatory model form? I mean, there's kind of the 6 models they have out there, but they don't cover all the different types of products that community banks offer. So what do you do when you have a construction to permanent loan or some other kind of mixed loan? Maybe it's a step rate that converts to a variable, things like that. How do you fit those within a form that is mandated when you don't have a mandated form to follow for that specific product? And really it's just going to take some judgment calls, I think, and really working through the model forms along with the product, and working through with your lending team, your implementation team, really, your compliance people, your lending team, your legal counsel, figuring out how to make that product fit within the mandated form as closely as possible. So implementation process, I'm not going to beat this to death, but if you don't have an implementation plan for this rule yet, you should get one started. You should get a team of people from the business units that have a stake in this rule, that are implementing it, to get together and identify the affected products and departments, identify your policies and procedures and technology that will need change to comply with the rule, and then really start planning early for training and testing. So training, it's going to take a lot of training for people that day to day are using these forms to figure it out. And there's going to be a learning curve, because you can't have a soft launch. The CFPB hasn't given you an option to have a soft launch and use it with some consumers beforehand. It's August 1st. The old forms are gone. You're starting to use the new forms immediately and thereafter. So the testing part is something that you should really start to plan for now, and talk to your vendors and ensure that you'll have sufficient time to internally test transactions through your processing system and generating the forms to get a feel for how they work, get a feel for any bugs or issues or hiccups there are, to minimize those to the extent you can before August 1st. And, it's unlikely it's going to be perfect. I mean, even if you really exhaustively test it, things are going to arise after August 1st that, you didn't see coming, or that, you don't know the answer to about how something is filled in or whether your forms work. So there's still going to be a learning curve, but I think with having an adequate time to test the forms, it will substantially reduce that learning curve.